It might be a short. I'm hoping it's not a short, but it very well might be a short. Yeah. Could we be suffering from a short? I think we have a short.
Computer 1, computer 2. You have two computers.
Can you hear me now?
Yes, I can.
Yeah.
Okay, can you hear us?
So I had to mute while we were waiting on you. I'm sorry. You weren't short. I was just short.
Okay, all right. So you can hear me though?
Oh, yeah, I can hear you fine.
Excellent. Okay, so we were still trying to narrow down our teams to our 4 who will be participating. So my intent today is to have 2 from each side go. Our girls' side is just about ready. Here's their question, also my question. My intent is to ask them questions. Would you be willing to ask them questions also in regards to the argument?
Oh, yeah, that'd be fine because I'm really just here to try to help you guys out. So if you can ask questions, we could ask questions. That's not a problem. And then we have some people to try to argue against them. So, you know, that would, and we're recording it so that then you can have the link this afternoon.
All right, excellent. All right, so I'll be showing them the time. I'm using a countdown to count up timer just to get them used to when the competition is actually time.
Okay. How long are your speeches?
It's scheduled for 5 minutes. However, when competition time comes around, what the bar and the courts have set up is it's 5 minutes speech time. However, the time stops when one of the justices, the judges will be asking questions.
So if you figure maybe 7 minutes, 2 minutes of questions, then that would be fine then, right?
Yeah,
okay.
That's the intent. All right, so let me get my girl side queued up since on competition day they'll be going first. Just to get you guys used to how it's going to be done, what the court will do is this. They'll call your team in, you'll sit in the gallery, and they'll say something along the lines of, now calling the matter of Audrey Arroyo and Brittany Buchanan versus the government of the Virgin Islands. Are the appellants ready to proceed? The appellants may approach.
Good afternoon.
Louder.
Oh, I'm sorry. Good afternoon.
Good afternoon.
The appellants may proceed.
Good day, Chief Justice and Associate Justices. May it please the court?
It does.
I am Reniqua Victorine, and I, alongside with my co-counsels, will be representing Audrey Arroyo and Brittany Buchanan in the matter before this court today. Your Honors, from my clients, America's paradise has become nothing but a beautiful limbo. Archaic laws serve as a barricade, barring my clients from a fundamental right that has always been recognized. This United States has shattered the artificial wall dividing marriage, but the Virgin Islands continue to place blocks before my clients. This matter is justiciable, and I provide you with the following hammer. 1. Marriage is and always has been treated as a fundamental right, and as such, any challenge to marriage must face strict scrutiny, as they always have. And 2, my clients, due to the chain of cases ending at Oberfeld v. Hodges, falls into a new protected class that also demands strict scrutiny. Firstly, Your Honors, marriage has always existed. It predates the Constitution, predates the United States, and though the right has evolved, as stated by Justice Kennedy in Oberfeld, it has always evolved as a fundamental right.
But counsel, hold on. Hasn't it traditionally been held that these challenges occur to marriages between opposite sex couples? I mean, until 2001, no nation ever recognized same-sex marriage. So why is same-sex marriage for your couples now, after a ruling just last year that attempted to equalize marriage, something that we must recognize as a fundamental right?
Your Honor, marriage is marriage, and every case that has involved marriage has needed strict scrutiny to be its provider. All Obergefell does is strengthen the definition of a fundamental right, making it inclusive of all U.S. citizens everywhere in the Union, no matter their sexuality. To tell my clients that they must go to the States every step of the way for everything required for a fundamental right does not pass strict scrutiny. Carmen DeVille, on behalf of the United States Virgin Islands government, may say now 15 days, but without declaratory judgment in favor of my clients. She could just as easily say, my clients can only be issued a marriage license on the first Tuesday in a month that begins on a Tuesday. This would not, cannot, and does not pass strict scrutiny.
But counsel, hold up. Are we faced with a situation where the only thing Ms. DeVille was trying to do was her job? If the laws on the books in the Virgin Islands says, and I'm referring to Virgin Islands Code Title 16, Section 31, marriage is between a man and a woman. Wouldn't she be breaking the law to issue your clients a marriage license?
Your Honor, no. Because Obergefell was passed on and marriage is a fundamental right that extends by its own force, she is therefore breaking the law. The Virgin Islands has done nothing to adjust anything in accordance with this clearly fundamental right, and this extended denial also does not pass strict scrutiny. This is not merely an attempt to skirt a constitutionally sound decision by the highest court in the land, Your Honors. This is the Virgin Islands.
Consular, isn't it true that the Virgin Islands are not able to vote in federal elections as well, even though they're U.S. citizens?
Yes, Your Honor.
And so wouldn't that follow that there are certain rights that Virgin Islanders do not get?
Your Honor, voting is a procedure, while representation is a right.
Okay.
This is not merely an attempt to skirt a constitutionally sound decision by the highest court in the land, Your Honor.
Hold on. You bring up a valid point. Representation is the right. So yes, Virgin Islanders are represented at least locally in that regard. And I would even say nationally in regards to being able to vote in primary. Voting is a procedure. But for your clients, wouldn't then marriage be a right, but getting a marriage license be a procedure?
No, Your Honor. This is the Virgin Islands declaring independence from the laws of the United States, all through the disenfranchisement of the rights. I note, the fundamental rights of U.S. citizens, and this discrimination must be addressed. The standard of review is strict scrutiny. Secondly, the chain of cases leading up to and including Obergefell functionally creates a new protected class, one in which my clients squarely fall.
Hold up. Is there any instance of the courts giving explicit language to say that a new protected class does exist and that your clients actually do get strict scrutiny? Or are you saying that the justices today must make that decision?
Your Honor, I will take you to 1993, where Bearview Lewin called for strict scrutiny for same-sex couples in regards to Hawaii's constitution. This case sparked motion for other states with separate laws to act to forestall such recognition. Congress passed the Defense of Marriage Act, or DOMA, in 1996, defining marriage federally as between one male and one female.
Hold on. Did DOMA extend to us by its own force?
Yes, Your Honor. This definition, this discrimination stood until 2013 when USB Windsor struck down DOMA on the grounds that marriage is marriage and segregating by sexuality was unconstitutional and had no legitimate, narrowly tailored, or even reasonable purpose to exist other than to bar homosexual couples from marrying. Your Honor.
Hold on. My next question then becomes this. If Congress passed the Defense of Marriage Act, and as such extended to the Virgin Islands, would it be your argument today, or could we interpret your argument today being that it wasn't really Obergefell that provides for Ms. Arroyo and Ms. Buchanan's ability to get married in the Virgin Islands? It's Windsor which struck down a national definition?
Yes, Your Honor. This paired with numerous other rulings like Lawrence v. Texas, struck down limits placed on homosexual rights, equally fundamental rights like privacy, shows that such limits would be equally appalling once placed upon a specific race, religion, or insular group traditionally discriminated against. If this were a matter of a white Virgin Islander being denied the right to marry a black Virgin Islander of Dominican descent, such a matter would face strict scrutiny.
But counsel holder, wouldn't that matter face strict scrutiny just on account of their race, though?
No, Your Honors.
Why not?
Because this would also include their sexual orientation, which is not a new protected class. The same standards should attach if these two individuals are both female. While employees under the government of the Virgin Islands are entitled to their own beliefs and preferred practices, Carmen Neville had no right to deny my client's marriage license. She may have felt it to be her civic duty to the Virgin Islands and her personal duty to God, but discriminating against a new protected class functionally created by the Supreme Court and discriminating in regards to a fundamental right she has personally enjoyed 3 times is a calamitous affront to equal constitutional protection. This court must address such constitutional claims. Your Honor, I see that my time has elapsed. May I conclude?
Yes, you may.
Thank you. In closing, the government of the Virgin Islands cannot act against precedent locally or nationally, and this discrimination cannot be allowed to continue. This court must provide declaratory judgment for my clients. Their right is fundamental. Any law, any wall placed before them must face strict scrutiny, a standard which the current flawed path the Virgin Islands hold to fails. And it is for the aforementioned reasons that this court should reverse the lower court's ruling. Thank you.
Good day, Chief Justice and Associate Justices. May it please the court. I am Kimari McLean, also representing Audrey Arroyo and Brittany Buchanan. Your Honors, white, black, statesider, of Puerto Rican descent, native Virgin Islander, from Down Island, or as people, as the locals say, born here. Christian, Muslim, Hindu, Seventh-day Adventist, even atheists. Once any of these individuals are U.S. citizens, they are entitled to fundamental rights. Every one of those stated individuals would have the equal and fundamental right to marry. That is, to marry in the Virgin Islands. In accordance with the 14th Amendment, that right and its corresponding privileges or immunities cannot be abridged without due process of law.
Hold up. The 14th Amendment says, no state shall abridge a person's life, liberty, or property without due process of law. Is the Virgin Islands a state?
Yeah.
And since the Virgin Islands isn't a state, what gives them due process protections? What extends the 14th Amendment to them?
Your Honors, Balzac v. Puerto Rico clearly states that the 14th Amendment does attach to territory. And such, even territories cannot deprive someone of their due process of law.
And then counsel, okay, you mentioned Balzac, which is one of the insular cases. As a matter of fact, in some circles, it's considered the last insular case. That case also says rights. As a matter of fact, it says fundamental rights do not automatically attach by their own force. Is marriage one of the enumerated rights of the Constitution?
Yeah, attaches by its own force, Your Honor.
No. Is it one of the listed numbered rights of the Constitution?
No, Your Honor.
Counselor, if it's not listed in the Constitution according to the 10th Amendment, who has the power to control it?
Congress. Can you repeat the question, please?
Yeah, if it's not enumerated in the Constitution according to the 10th Amendment, who has the power to control it?
Congress, Your Honor.
Yeah, it ends up being Congress for you. So was this, Obergefell was not a congressional right then, was it?
Obergefell is not a congressional action, is it, counsel?
No, Your Honor.
So if Obergefell isn't a congressional action and it's not enumerated in the Constitution, how is it that your clients come before us today making a claim in regards to a right that's not stated anywhere in the Constitution of the United States?
Because, Your Honor, even if it's not stated in the Constitution of the United States, even if it's not stated in the Constitution of the United States, if a right is truly fundamental, it extends by its own force. I will go to my first point, Your Honor. As clearly stated by Justice Kennedy in U.S. v. Windsor, and restated in Obergefell v. Hodges, Couples of the same sex may not be deprived of the liberty to enjoy the fundamental right to marry, simply on account of the same-sex nature of their marriage. My clients knew this. They started a marriage license immediately after Oberfell. The right to marry for them was fundamental. They were turned away. The executive order recognized and pointed out why marriage is fundamental, pointed out why the Virgin Islands should follow. My clients returned and were again denied. Nothing can substantiate this denial, Your Honors.
Hold on. I'm not even sure your clients are actually being denied our right. If we look to Balzac, in regards to trial by jury, Mr. Balzac in that case didn't gain that right, not because of the fact that he wanted it or that it was fundamental. He didn't get it because locality determines the extension of constitutional rights. But in your clients, just as if any Virgin Islander wanted to vote, relocate to the States, gain their marriage license, and then exercise their right fully and free of the issues caused by the insular cases?
Yes, Your Honor, they could have. But to begin with, respectfully, Virgin Islands Code Title 16, Section 35, which states the qualifications for the applicants of marriage license, has no requirement that disqualifies my clients from a marriage license. Section 38 further reinforces that the requirements stated in Section 35 are all that is needed to be issued a license addressed to some particular minister, judge, or other person authorized to solemnize marriage. Mrs. Arroyo and Buchanan fit Section 35 in all essential ways.
So, Council, hold on. What you're saying is, during the creation of Virgin Islands law, they provided a definition, but didn't require a definition for the documents necessary to partake in it?
Yes.
And because of that, your clients, even if they came before Obergefell was decided, should have been given the ability to fill out a marriage license application?
Based on Section 35 and 38, yes, Your Honors. This is because there is no G requesting the sex of both petitioners, nor an H stating that the sexuality must be in accordance with local definition or any definition in fact. The denial of my clients from even beginning a process they would easily pass is a denial of due process and arbitrary and capricious actions by state actor Carmen DeVille can easily be ruled a violation of my client's equal protection as pointed out in Baker v. Hall.
Counselor, are you arguing that because there is no gender on the form, that the law that says in the Virgin Islands that a man and woman could not get married is moot?
Yes, Your Honor.
So a typographical error can override the law.
Yes, Your Honor. Further clarified, I'll even provide an analogy, Your Honor. A new car model comes out each year. If they are equally a car, there is no need for a new type of license. This brings me to my second point. Marriage has faced the same evolution as privacy, proven in Lawrence v. Texas. The same evolution as other rights in regard to same-sex couples. Strict scrutiny, or at least the language calling for that standard, has been used more often in matters involving same-sex couples. Yes, marriage has grown by state action, but through the courts, it has evolved past race, Loving v. Virginia, been shown as fundamental even to prisoners, Your Honors, prisoners, Turner v. Safley, and cannot be barred from even those who owe child support from a previous marriage.
But then, Counsel, hold on. Those three cases you mentioned, yes, they do show new extensions to the right to marry. However, each of those cases dealt specifically with opposite-sex marriages. If I recall correctly, Oberfell even points out that after Loving v. Virginia, a same-sex couple from Wisconsin tried to make a claim to marriage being fundamental. The court didn't hear their case. So why do those cases now provide your clients with the ability to challenge when it really had nothing to do with the type of marriage they seek?
Your Honors, this chain of cases was used to prove that when marriage is in question in the court, it has always faced strict scrutiny, or at least the language calling for it. To emphasize, Your Honors, truly fundamental rights attach even while a citizen is incarcerated. A prisoner's speech, religion, or petition cannot be limited without facing strict scrutiny. Turner v. Safley provides the same for marriage. Mrs. DeVille's actions are in opposition of her prescribed duty. There were no actions taken to help my clients understand why they were being denied. Nothing in Section 35 denies them. The actions of a state actor stripped away a fundamental liberty without even providing them a chance to fail the process. And these actions must be addressed under and will fail strict scrutiny. My clients have been denied due process. Agents of the government, under the color of law, cannot apply the law to violate a fundamental right. Such actions and laws fail strict scrutiny.
Counsel, if we were to rule today that, yes, marriage is a fundamental right within the 50 states of the United States, until Congress says it is a fundamental right for the territories, it is not. Can your client still make this due process claim?
Can you restate your question, Your Honor?
Okay, let us say today the justices decide that marriage is only fundamental and attaches by its own force to the United States. Do your clients still have a case?
Your Honors, if that was the case and they stated that directly, then no, they would not. But the council never stated that. Marriage was declared as a truly fundamental liberty. And anything that is truly fundamental attaches to the territories by its own force. The least Ms. Arroyo and Ms. Buchanan deserve is a chance to begin the process afforded to them to take part in the grand institution, the fundamental right, the union simply called marriage. It is for these reasons that this court should reverse the lower court's decision and place judgment in favor of my clients. Thank you. I see I have 9 seconds left. May I yield the rest? I yield the rest of my time to the court.
All right.
Good afternoon, Your Honors.
Good afternoon.
Mr. Chief Justice and Associate Justices, may it please the court. My partner, Brisa Rodriguez, and I, Cecilia Perez, represent the Virgin Islands, the respondent. I will speak for 5 minutes on the first point of error, and my partner will speak for 5 minutes on the second point of error. Your Honors, the question I will be addressing to the court is whether U.S. Virgin Islanders' complaint urging the application of the fundamental right to marry to citizens of the U.S. Virgin Islands is a non-justiciable political question, meaning if a federal court can or cannot hear a case. The answer to the question is an unequivocal no. In 1917, the U.S. bought the islands from Denmark for $25 million in gold for military purposes. The United States Congress granted citizenship to Virgin Islanders in 1927. At that time, the islands were co-managed by the United States military and the Department of the Interior, and they remained under this arrangement until the passage of the Organic Act in 1936. The Organic Act of 1936 established 2 municipal courts in the Virgin Islands and 1 council for the whole territory. In 1954, Congress revised the Organic Act to abolish the independent municipal councils and authorize the establishment of distinct executive, legislative, and judicial branches. The revised Organic Act provided for a substantial degree of self-government and has ever since served as a constitution of sorts for the territory, which means that they are actually a government which is able to make some of their own decisions, laws, and policies. Now, this is why the Moot clerk of the court was just doing their job, and this is why the Moot clerk had denied Ms. Arroyo's and Ms. Buchanan's request for marriage license. Now, the 14th Amendment, Section 1 states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the laws. Now, we must realize that even my opposing counsel said that the Virgin Islands is not a state, therefore meaning that Obergefell v. Hodges cannot apply, because in Obergefell v. Hodges it states that the same-sex marriage applies only to the states, which is the point that my co-counsel will be addressing further on in detail. just meaning that taking out the petitioner's case and argument of trying to say that the 14th Amendment does apply and that Obergefell v. Hodges should apply, which in this case it does not, because if we take a close look at the way that the 14th Amendment is worded, it says that states, and the Virgin Islands is only a territory of the United States.
But counsel, my question would then fall to this. If individuals in the Virgin Islands, and specific to our case, Mr. Roy and Ms. Buchanan are U.S. citizens, are territories allowed to act with more power than the states to limit the rights of U.S. citizens?
Well, Your Honor, we must look at the Organic Act of 1936, which they were able to make their own constitution, and the states are able to make some of their own laws and policies, and so can the Virgin Islands. So it's just power that they both have. None of them actually have more power than another. So taking a look into the Virgin Islands Code, Title 16, Section 31 states that the nature of marriage is hereby declared to be a civil contract which may be entered into between a male and a female in accordance with law. And this is why Ms. Buchanan's and Ms. Arroyo's request to have an official marriage license was denied at the time, because this is a violation of the code Title 16, Section 31, which just states that that the nature of it is it's always been between a male and a female, therefore meaning that they would just violate this code of the Virgin Islands. Now, the Virgin Islands is able to make some of their own decisions based of the Organic Act of 1936, which they're able to have some sort of self-government and make their own policies and rules. So the Virgin, since it's not a state, Obergefell v. Hodges does not apply, such as the petitioner has attempted to argue, because in that case it says that it only applies to the states, and again, the Virgin Islands is a territory rather than a state, therefore that case does not apply, taking out the petitioner's argument. Now, cross-applying Valle v. Puerto Rico.
Counsel?
Yes, Your Honor.
We were just about to mention Valle v. Puerto Rico, which is what I'm going to get to right now. The Virgin Islands has been a territory of the United States for 99 years. Their centennial will be 2017. The fact that they are unincorporated territory shackles them with the insular cases, which include Valle v. Puerto Rico. Looking at that amount of time and the closeness that the Virgin Islands now holds with the United States, would rulings like Obergefell and other Supreme Court decisions that do not directly state they apply to territories apply to the Virgin Islands if it was an incorporated territory rather than an unincorporated territory?
Well, Your Honor, in Valle v. Puerto Rico, it says that it was a case in which the Supreme Court held that certain provisions of the U.S. Constitution does not apply to territories, therefore meaning that this argument that the petitioner is trying to make about the fundamental right does not apply to the Virgin Islands. Why? Because it is, may I answer the question, Your Honor?
Yes, you may. Then you can conclude.
Yes, and my counsel will get further into detail, but we must realize that the Virgin Islands is a territory rather than a state, therefore meaning why it doesn't apply, and we pray for these reasons that you vote to uphold the lower court decision. Thank you. Hi, good afternoon. Opponents ready? Your Honor, ready? Mr. Chief Justice and Associates, may it please the court?
It does.
My partner, Cecilia Perez and Iris Rodriguez-Muro, will represent the respondent, the government of the Virgin Islands, in the case before the court today. Your Honor, this case is about the law and the upholding of it following the Constitution that our founding fathers made in the beginning of our great nation. The question I will be addressing is whether the Virgin Islanders are entitled to the adoption of same-sex marriage as a fundamental right through the application of the Due Process Clause and Equal Protection Clauses of the 14th Amendment to the United States Constitution. Now, to answer this question, it simply is an unequivocal no. The Virgin Islands are unincorporated territories. An unincorporated territory in American law is an area controlled by the United States government where the fundamental rights apply as a matter of law, but other constitutional rights are not available. Now, selected constitutional provisions variously apply depending on congressional organic acts and judicial ruling according to the U.S. constitutional practice. Now, local tradition and law. All 5 modern inhabited territories are organized but unincorporated. So, answering the question, the Virgin Islands are unincorporated territory. And of course, following the Organic Act that was established in 1936, of course, cross-applying all of my co-counsel's arguments, then no, not all rights should apply. And in this case, this is nothing more but a privilege that will only apply to states. Now, yes, Your Honor.
You mentioned that the Organic Act is which was decided upon by Congress for a territory, is what provides for fundamental rights to the territory. The Organic Act of the Virgin Islands, and this is stated in the executive order, provides for the due process clause, and as a matter of fact, the entirety of the 14th Amendment under Article 11. Article 11 granted the exact same language used for the 14th Amendment to the Virgin Islands when it was applied. If that is the case, do the appellants have a case with the fact that Congress has already provided an action that can allow them to make a claim?
No, Your Honor. Simply because the appellants actually cross-applied over Valle v. Hodges. However, again, it was not a congressional hearing. It was actually done by the Supreme Court, and the Supreme Court held that it should apply to all 50 states. And in that contention, it was referring to the 50 states of the United States of America. So since it wasn't a congressional hearing, it would not apply to a territory, as Congress is the one to make decisions where they feel necessary, because of course the Virgin Islands are unincorporated territory, so therefore Congress has the power to interfere. Now, cross-applying Baker v. Carr, it states the Supreme Court addresses the court's political question doctrine and held that federal courts have the right to intervene and decide on redistricting cases. Now, this case completely takes out any argument that the petitioner may attempt to make, because following the Organic Act, again, the lack of the Virgin Islands Constitution shows that the Virgin Islands attain to the U.S. Constitution and only follows federal law enacted by Congress. Now, also cross-applying Balzac v. Porter.
Counsel, hold on. Counsel, you just mentioned something very important, and I'm not sure if it benefits you. The Virgin Islands has to follow, congressionally decided federal law.
Right, Your Honor.
The Defense of Marriage Act provided a federal definition of marriage, which was later ruled unconstitutional. So the Virgin Islands has to follow federal law, and the Supreme Court overrules federal law. Are we not placed with a case where, because federal law provided the same definition as the Virgin Islands, that neither could stand?
Your Honor, we have to take into, Your Honor, we need to look at the fact that the law stands. And of course, since the Virgin Islands are unincorporated territory, the federal law is the law that will stand. Now, the Supreme Court applies to all states, and the Virgin Islands are not a state. They are an unincorporated territory, if I may add so. They are a territory, but they are also unincorporated. So, of course, again, following the definition that was established regarding unincorporated territories under American law, it clearly states that fundamental rights apply as a matter of law, but other constitutional rights are not available. So therefore, the argument that the appellant has made regarding the 14th Amendment and the due process and equal protection clauses under the 14th Amendment, they would be unapplicable in this case. Does that answer your question, Your Honor?
Yes, counsel.
Now, in Balzac v. Puerto Rico, the Supreme Court held that certain provisions of the United States Constitution did not apply to territories not incorporated into the Union. Applying this binding case to our case demonstrates exactly why we are here today. We are all well aware that Puerto Rico is a Commonwealth. The Virgin Islands are a territory, unincorporated territory, therefore completely following the Supreme Court holding. So therefore, this case is fully binding and essential to take into consideration when making a decision. Now,
But then, hold on. Balzac also says, and this is right in the same section where it points out that though trial by jury may be fundamental to the United States, it didn't extend to Puerto Rico at the time. It says right after that the due process clause of the 14th Amendment attaches to all territories by its own force, because that is where most litigation for U.S. citizens comes from.
Your Honor, you said it yourself. It applies to all territories. However, the Virgin Islands are unincorporated territories. So following American law, those rights would not apply.
But counsel, so was Puerto Rico at the time. And then Balzac had pointed out that Puerto Rico and the Philippines inherit that. Puerto Rico, though a commonwealth, by designation, is still an unincorporated territory. So would it not hurt your case if the due process clause did come? Or is there a process that could still be afforded to these ladies if the due process clause does extend to them?
No, it still wouldn't, Your Honor. Again, following federal law and as it stands today, right? Because we're arguing how the law stands today. So, of course, we cannot go back because Puerto Rico is a commonwealth now. And, of course, yes, this was a landmark case. So, yes, this is a binding case. Why? Because, again, the Virgin Islands are unincorporated territory. So it's clearly stated under American law that not all constitutional rights are to be applied because they are unincorporated territory. Does that answer your question, Your Honor?
Yes, counsel.
Now, even though the Virgin Islands are unincorporated territory, we understand that they still have such privileges. However, they must understand that they are to follow federal law, as Congress is the one to lead whenever it comes into a redistricting case in which they should be able to make their opinion. So for these reasons, and these reasons alone, we pray, cross-applying all of my co-counsel's arguments, that there is no way that the appellants can make the case regarding as to whether they are entitled to same-sex marriage under the 14th Amendment, because it is clearly stated under American law that unincorporated territories have the fundamental rights, but not all constitutional rights are to be applied. Thank you.
That's what you're telling yourself.
Oh, I see that I have 1 second left. I'll leave it to the court. Thank you.
That was excellent.
That was really great.
So now you see how many different ways you can approach the argument separate to what we do, right?
Yeah.
Feeling good about yourself now?
Yeah.
You sure?
I said that. I'm like, okay.
Is he like, come on? No. I just have to slow
All right.
down.
So we have our respondent team also. Would you be prepared to operate under the side of the appellants while our respondent team preps to go ahead?
They want you to appellant, so that
I asked my co-counsel. Yeah, well, if you guys are available, then yes, sure. Just she's first speaker, so I'll allow my co-counsel to trade spots.
All right, take your time. Let me get mine ready also. Don't rush. Take your time. Side two, government. All right, Alice, you ready? All right, any question?
Opponents ready?
Give us a sec. All right, Alice, you're doing the process. Other justiciability government to make. Excellent. Doing justiciability or due process? Oh, you doing justiciability? Who was due process government?
No, I say I can't do that. I can't do that.
Graciela is the process.
Ooh, Graciela is definitely.
One nation.
Marialis, you can do both.
I did not fix it for me yet.
All right. So, Marialis, you're going to do justiciability.
I'll do the process. It's fine.
We have to do process on that side.
Me and Graciela.
Ah,
And then Chris. I know how to do process.
all right. What are you going to do process? You have to just trust somebody's going to do process today.
No, I don't do it. He would do it. I do my argument. I practice last night. Do it. I want to do it. We're not going.
All right, people, let's go.
I am. Take the process. Where's the process?
All right. The respondents may begin. I'm sorry. The respondents, are you ready? Respondents, ready? Respondents, are you ready? Yes. Appellants, are you ready?
Yes,
Yes, Your Honor.
Yes, Your Honor.
You may proceed.
Mr. Chief Justice and Associate Justices, may it please the court.
It does.
My partner, Brisa Rodriguez, and I, Cecilia Perez, will present Ms. Arroyo and Ms. Buchanan, the petitioner. At this time, I will speak for 5 minutes and address the first point of error, and my partner will speak for 5 minutes and address the second point of error. So, Your Honor, the question that I will be addressing is whether U.S. Virgin Islanders' complaint urging the application of the fundamental right to marry to citizens of the U.S. Virgin Islands is a non-justiciable political question. The answer is yes, because it is a fundamental right which was decided in Obergefell v. Hodges, and courts can decide over this, such as if we take a look at Obergefell and v. Hodges, which was decided in June 26 in 2015, in which the Supreme Court decided that the fundamental right is guaranteed to same-sex couples, which does apply to our case, because if we take a closer look at Section 3 of the Revised Organic Act of 1954 as amended, provides that no law shall be enacted into the Virgin Islands which shall deprive any person of life, liberty, or property without due process of law, or deny to any person therein equal protection of the laws. Therefore, meaning that actually in the United States Congress, by enacting the Revised Organic Act of 1954, made the due process of the 14th Amendment directly applicable to the territory of the Virgin Islands of the United States. Therefore, meaning that Obergefell v. Hodges does apply to our case, because in the Organic Act of 1954, it states that the 14th Amendment and due process is applicable to the Virgin Islands, therefore meaning that Obergefell v. Hodges does apply, because we are also under the United States, and we cannot, if we're going to consider them as United States citizens, we need to give them, the Virgin Islanders, Ms. Arroyo and Ms. Buchanan, and more people, their fundamental right to same-sex marriage, because we cannot give rights to people that live in the States and not people that live in the Virgin Islands, because the Organic Act of 1954 allows it to be applicable.
But counsel, aren't we faced with a situation where Congress has in effect already done that, not just to the Virgin Islands, but to all territories? Representation is given to them, yes, but they can't vote for their commander-in-chief. People in American Samoa, they aren't even citizens. They don't even get the full extent of the first portion of the citizenship clause of the 14th Amendment. So while they can provide soldiers, they can't vote for their own commander-in-chief until they move. Couldn't this be the same situation facing Mr. Arroyo and Ms. Buchanan? Their issue isn't that the Virgin Islands is denying them marriage. It can't be provided because of their locality. Just like voting, they don't get it until they actually are within the contiguous 50. Wouldn't that be the situation facing your clients?
Well, Your Honor, we must take into account that the governor of the Virgin Islands, Kendrick Matthew, did sign an executive order entered on July 27, 2015, requiring the territory's government to comply with the U.S. Supreme Court that ruled that marriage rights to same-sex couples throughout the country, which was in Obergefell v. Hodges, therefore meaning that it should apply. And if this executive order was signed and Mr. Arroyo and Ms. Buchanan were denied their same-sex license for marriage by the Moot clerk, then they are being denied their rights, Your Honor, because it was decided in Obergefell v. Hodges, which my co-counsel will also address, that it was a fundamental right, and therefore they're depriving Mr. Arroyo and Ms. Buchanan of their rights. And actually, when this executive order was signed, Ms. Arroyo and Ms. Buchanan did attempt for a second time to try to get their license of marriage. However, they were denied, and they were denied quite a few times.
But counsel, I agree that they did attempt a second time, 4 days after the executive order was passed. Was 4 days enough time for them to act?
Well, Your Honor, yes, it was enough, because the executive order was signed and entered on July 27, 2015. So as soon as that executive order is signed, it is now it's now in place. It's taking action. Therefore, this is why Ms. Arroyo and Ms. Buchanan did take action and to make another attempt to get their license of marriage. However, they were denied by the Moot clerk, and this is why I'm arguing that they're actually indeed being denied their rights, because on June 26th of 2015, the Supreme Court of the United States ruled that the 14th Amendment requires the state to license a marriage between two people of the same sex and recognize marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. Now, the respondent may try to argue that the Virgin Islands is not a state. However, we must realize that the Virgin Islands is still a part of the United States, and that the Organic Act of 1954 makes the due process of the 14th Amendment directly applicable to the Virgin Islands, therefore meaning that Obergefell v. Hodges does in fact apply to our case. And just...
So I have to go back to executive order for a second. In looking at the executive order, it says that in 15 days, a status update would be provided on the status of these changes. Mr. Arroyo and Ms. Buchanan went back long before 15 days. They went back in 4. If nothing was changed yet, they went back on a Thursday, if I remember correctly. The executive order was issued on a Monday. If 15 days hadn't passed yet, can they still make the claim, or did their haste eliminate their challenge before the court today?
However, Your Honor, they kept constantly denying them the. Can I answer the question, Your Honor?
Actually, you can. I have one more and then I'll allow you to conclude.
Yes, they kept denying them their fundamental rights, which was decided in Obergefell v. Hodges, and we must give Ms. Arroyo and Ms. Buchanan their fundamental rights. We pray for these reasons that you vote to overturn the lower court's decision. Thank you.
All right, my last question for you, counsel, is this. Is it your contention today that though there was a 15-day grace period, for lack of a better word, to check on the implementation, that even if that was the case, Carmen DeVille, the clerk of the Moot Superior Court, would still have denied them the ability to get their marriage license, even if those 15 days passed?
Well, Your Honor, we must realize that they were still denied their fundamental right to same-sex marriage, and for these reasons, we're asking that they're given their rights, because the Organic Act of 1954 and even the executive order that was signed, it must apply, but they just kept constantly getting denied the request made. Thank you.
All right, counsel. Thank you.
Sorry. Good afternoon.
Good afternoon.
Mr. Chief Justice and Associates, may it please the court?
It does.
My partner, Cecilia Perez, and I, Brisa Rodriguez, will represent the petitioner, Audrey and Brittany, in the case before the court today. Your Honor, this case is about justice and granting citizens the rights that were constitutionally granted by our founding fathers. The question I will be addressing today is whether Virgin Islanders are entitled to the adoption of same-sex marriage as a fundamental right through the application of the Due Process Clause and Equal Protection Clauses of the 14th Amendment to the United States Constitution. The answer to this question is a yes. Even though the Virgin Islands are U.S. territory, they will have privileges such as citizenship. In Tuawa v. U.S., the court held that persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. Now, citizenship is defined in the Constitution as the attribute of persons who, as members of polity, have certain privileges and duties in addition to those they have as persons. Now, citizens include those born in the United States, state territory, or naturalized according to law. Now, cross-applying the Constitution and to all of the U.S., the Virgin Islanders are citizens and the Virgin Islanders are incorporated, for they are territory and they are indeed under the jurisdiction of the United States of America. When it comes down to rights created through social contract, it clearly says that a citizen is to enjoy equally the rights, privileges, and protections of personhood as established by law. without further ado, then that would clearly state that yes, the Virgin Islanders are entitled to indeed have an approbation of their marriage license. Now,
But hold on. You mentioned Tuaua. And Tuaua, the U.S. also brings up a very interesting point. That case says that though a right may be fundamental, for a right to be truly fundamental, it cannot be in merely a colloquial sense or considered necessary for the American form of order and liberty. What I draw from that is it's saying that though a right may be considered fundamental in the United States, meaning the 50 states, it isn't necessarily fundamental to a territory. That's the reasoning they use while referencing the insular cases to speak about American Samoa in regard to citizenship. Is marriage so fundamental that the Virgin Islands gets it, even though until 2003, the United States didn't even recognize same-sex marriage as fundamental within its own borders?
yes, Your Honor, definitely. Times have changed. And as time goes by, we must apply our Constitution to the times as they change. Because, of course, we need to make sure that everyone is applied the same rights. Again, going back to the definition of citizenship, under the actual Constitution, citizenship applies to people of territory, people of state, and people naturalized into the United States. So therefore, not only that, but cross-applying Tuaua v. U.S., Tuaua also says that citizens are people under the jurisdiction of the United States of America. And Virgin Islands being a territory would imply that, yes, they are under the jurisdiction of the United States of America. Does that answer your question, Your Honor?
Yes, Counsel.
Now, the court held going on to another argument that I will make is that they have access to the United States judicial system. The Superior Moot Court and the Supreme Court work together in unison to make sure that all citizens are granted the same rights. Why? Because they are citizens. And if they weren't to be granted the same rights, that would be unconstitutional. So therefore, they work together. So if that were the case, it is truly clear that we should apply Obergefell v. Hodges. Now, the court held that the Due Process Clause of the 14th Amendment guarantees the right to marry as one of the fundamental liberties it protects, and that analysis applies to the same-sex couples in the same manner as it does to opposite-sex couples. Now, the judicial precedent held that the right to marry is a fundamental liberty because it is inherent to the concept of individual autonomy. It protects the most intimate association between two people, and it has historically been recognized as the keystone of social order. So therefore, it clearly states that it is applicable under the Due Process Clause of the 14th Amendment, clearly answering the question I am here to answer today. Now, not only that, but if they were to truly work again together, both the Superior Moot Court and the Supreme Court, then this should apply, especially if we have an executive order that was signed by the governor. Executive Order 473-2015 clearly stated that no law should be enacted in the Virgin Islands which shall deprive any person of life, liberty, or the pursuit of happiness without due process of law, or deny any person therein equal protection of laws. Now, it also stated that the United States Congress said that by enacting the revised Organic Act of 1954 made by the Due Process Clause of the 14th Amendment directly applicable to the territory of the Virgin Islands of the United States, cross-applying the argument made by my co-counsel. So for these reasons, we pray that you uphold the law as it stands. Why? Because we're here, because the law is there to make sure that our society is under control. We are here and we plead the court to take into account the Constitution that was written by our founding fathers in the beginning of this great nation. We cannot simply just pick parts of the Constitution that we seem to interpret better than the other. Why? Because the founding fathers meant for the whole Constitution to be something for everyone, every single citizen. And Virgin Islanders are citizens of the United States of America under the definition of citizenship of the Constitution.
Counsel, I realize you're just about done. However, you mentioned 3 cases that build to something that I think we have an issue with before the court today. Baker v. Carr says that governments gain their power from the concern and the wills of the governed. Tuaua v. U.S. says that for the U.S. government to force rights onto a territory when they are not culturally, legally, or traditionally prepared to accept them, would be an act of paternalism, if not outright overt imperialism.
Your Honor,
Aren't we faced with a situation where to say that the Virgin Islands must know when they haven't had the conversation present in Oberfell, where they haven't had the debates or the campaigns present in Oberfell, must now accept something they've never thought of? Would that not be a political question where the US government is changing status now as they see fit to allow a right that they themselves like?
Your Honor, I'm aware that Baker v. Carr was landmarked a long time ago, but there's also Boumediene v. Bush, in which the Supreme Court held that the Constitution grants Congress and the President the power to acquire, dispose of, and govern territory, but not the power to decide when. May I finish answering the question?
Yes, you may.
Again, it gives them the power to acquire, dispose of, and govern territory, not the power to decide when and where terms apply. So putting that out there, that clearly states that, yes, they have the power to acquire, dispose of, and govern the territory, but they do not have the right to judge when any order set by the government of the Virgin Islands is to apply. So following Executive Order 473-2015, it should be applicable to our case today. Thank you. Does that answer your question? I did do it great.
That's counsel.
All right. Thank you, Your Honor.
All right. That's a black friend, because we did have it earlier. We had a case last year. That's a black friend. All right, respondents. Let me adjust so you can see our time. You see them, we flip the screen, and I just plug it away. That is fine. All right. This up a bit. Got you. Get frame. Yes, we frame. Take my mouse.
Mr. Iron, you know I need my guess on your face. You have it on the bottom.
No. I have the case. We had a case last year. So all right. Are the respondents ready to proceed? Yes, ma'am. Respondents may approach.
May it please the court?
It does.
Good day, Chief Justice and Associate Justices. My name is Christopher Jimmy, and I, alongside my co-counsels Mary Alice, will be representing the government of the Virgin Islands in the matter before the court today. Your Honors, this is not a case about morals, virtues, personal beliefs, or pious opinion. The Virgin Islands government did not, does not, and has not denied Ms. Arroyo and Ms. Buchanan the right to marry. Ms. Arroyo and Ms. Buchanan's complaint is a non-justiciable one, and no entitlement of the adoption of same-sex marriage as a fundamental right exists in the Virgin Islands via the due process or equal protection clauses of the 14th Amendment of the Constitution. I will speak to the matter of justiciability, while my counsel will address due process and equal protection questions. Today, we request that this court affirm the lower court's ruling. This matter is non-justiciable for the following reasons. 1. The relationship of the Virgin Islands to the United States does not mean all mandates will be automatically and immediately attached to the islands or its citizens. 2. A coordinated branch of the United States government, the legislative branch, and not the judiciary branch, must provide independent resolution of this matter.
Counsel, hold on. Opposing counsel brings up a very interesting point. It's not the legislative branch that acted to adjust law. It's the executive, via the executive order. Doesn't the executive order provide for the congressional action, since it is a law, for Ms. Arroyo and Ms. Buchanan's complaint?
Unfortunately, Your Honor, the executive order passed by Governor Kendrick Matthews is actually a moot point because it acts outside of the Virgin Islands Constitution.
How so?
Your Honors, a law does not exist that grants gay marriage equality in the Virgin Islands. Therefore, we cannot provide a marriage license. To go outside of that and provide one on its own, when a clear state definition of what gay marriage is acting out, is overreaching in the executive power.
So then, counsel, what, in your opinion, what exactly did the executive order do? If it didn't provide for a change of law, what did it do?
Your Honors, the executive order granted a I'm sorry, Your Honor, a moment of deference.
All right, let me rephrase that question. The executive order was passed, right? And it was passed with the intent of extending the ruling of Oberfeld v. Hodges. If we look at it in its writing, your argument is that it's a moot point. That, one, it's an overreach. It does nothing to benefit Mr. Roy and Ms. Buchanan. Why not? Then what does it actually do? If it didn't give them the ability to get their marriage license, what did it do? I'm still running, counsel.
Your Honor, the executive departments, its agencies, and instrumentalities had to comply with Oberfeld v. Hodges. The executive department had 15 days to provide a status update. The legislature had no mandate, no set time, no sessions to change laws to allow the executive to execute a change of law. This would then provide for this court to rule upon.
Then, counsel, okay. I agree with you that the legislative department will have to change the law as written. However, what if we're now faced with the fact that the executive order does provide a law? And that law is the U.S. definition of marriage. Isn't it, since you're arguing for justiciability, isn't it this court's duty to provide the interpretation as to which of these two competing laws we should follow?
No, Your Honor.
Why not?
Your Honor, the Virgin Islands is not a state. As of now, it's not even on its way to becoming a state. The Virgin Islands' current political status is an unincorporated territory, to which all laws and rights do not extend ex proprio vigore. Laws Act of Puerto Rico held that the Sixth Amendment specifically points out that in the fact the entirety of the Bill of Rights does not extend, minus congressional actions. 2 v. U.S. shows that the citizenship clause of the 14th Amendment cannot attach by its own force, even be forced to without the people seeking its own on their own. While the insular cases may be looked on as anachronistic, sometimes contentious, incourious, or even without parallel in the judicial history, as stated in 2 they have not been overruled and must provide the analytical framework in the territorial matters.
Well, Councilor, if the insular cases must provide the analytical framework, and Balzac v. Puerto Rico is one of those insular cases, and in that case it says that the 14th Amendment's due process clause does extend to the territories. And Oberfeld says that marriage is fundamental, and fundamental in regards to the liberty rights of a citizen of the United States. How can it not extend to Mr. Roy and Ms. Buchanan in the Virgin Islands, and why doesn't the executive order provide that for?
Let's change today. Number 15 is 64. 15 is now 64. Students don't have
The power to extend rights to citizens of the territories has been wholly given to Congress through Articles 4, Section 3 of the U.S. Constitution that provides Congress with the ability to make all needful rules for the territories. VI Title 16, Section 31 defines marriage as a union between a man and a woman. To change our standing law to suit Oberfeld v. Hodges is a job not within the court's power to do. Baker v. Carr states that where the Constitution assigns a particular function wholly and indivisibly to another department, the federal judiciary does not intervene. This matter belongs to the legislative branch of the Virgin Islands government. Your Honors, an analogy can suffice in this situation. Just because the national menu, SCOTUS, says it's available, the restaurant head chef, Governor Matthews, says the food is ready, and even if you're starving, it does not mean, Your Honor, may I please finish?
Yes, you may call.
It does not mean that you can take the food from the pot in the kitchen, as Ms. DeVille. You must wait for the server to bring it. The territories are not a buffet of constitutional rights. Congress must provide the platter before you are able to enjoy this food at your leisure. This is the case with marriage. In short, same-sex marriage rights, rulings, and even mandates do not attach to territories, minus congressional action. Congress has taken no such actions, and Article 4, Section 3, paired with the Insular Framework, marks Congress as the sole branch of government in charge with such extension. This matter belongs in the legislative branch of the United States, and more immediately, the legislative branch of the Virgin Islands. The question is political, the matter is non-justiciable, and thus, this matter is the decision of the lower court should be affirmed. Thank you.
All right. Where did you go? Where's your glasses? Where did you go? Where's your glasses?
Your Honors, may it please the court?
Proceed.
I am Mary Alice Prosper, also representing the government of the Virgin Islands. Your Honors, I reiterate the words of my co-counsel. This is not a case about morals, virtues, personal beliefs, or pious opinion. We are not denying Ms. Arroyo and Ms. Buchanan equal protection, nor have we denied them due process. The procedure these women seek exists in the United States, but does not in the Virgin Islands, and cannot until congressional action extends such a procedure to the territory. Furthermore, the executive order and Obergefell v. Hodges do not provide the necessary force to extend same-sex marriage to the Virgin Islands. It is for these reasons that this court should affirm the lower court's decision. To my first point, we cannot deprive one of something that does not exist. The right was not denied because of Ms. Arroyo and Ms. Buchanan's sexuality. It does not exist because it has not been extended to our established locality. Article 4 of the Constitution, paired with the language in Balzac, grants Congress the ultimate say in matters of the territory. Where the Constitution assigns a particular function wholly and indivisibly to another department, the federal judiciary does not intervene.
Counsel, hold on. What are you doing? Fundamental rights, aren't we?
No, Your Honors.
So, okay. So if we're not, would you agree that, looking at Balzac, the due process clause of the Constitution extends the Virgin Islands, correct?
Yes, Your Honor.
And Obergefell states that marriage is a fundamental right inherent in a person's liberty under the due process clause of the 14th Amendment, correct?
Yes, sir.
If that is the case, is it your contention today that though the due process clause may be fundamental and attacked by its own force, that challenges to other rights under that clause do not attach to the territories by their own force?
Yes, Your Honor.
Would that be the same argument if you were looking at one of the enumerated rights of the Constitution? Let's say this was an argument for speech or assembly. Would you argue that that type of right doesn't attach by its own force?
Your Honors, the two rights that you mentioned do attach by their own force, but as you stated, marriage is not an enumerated right in the United States Constitution. To my next point, just as a Virgin Islander who wishes to vote for president can move to the United States in order to vote, Ms. Arroyo and Ms. Buchanan can equivalently get their marriage license with all rights and immunities provided by the U.S. Constitution, and then return to the Virgin Islands and enjoy the rights of a married couple. Same-sex marriage is not fundamental in regards to the territory. Your Honors, as stated in Duncanville, Louisiana in 1968, quoted by Valle v. Villacrucis in 1990, and cited once more in Tuar v. West just last year in the same month that the Supreme Court ruled on Obergefell. It is not sufficient that a right be considered fundamentally important in a colloquial sense, or even that a right be necessary to the American regime of ordered liberty. Though the United States may see same-sex marriage as fundamental for the Union, its reach stops at the borders of the 50 states. Trial by jury, though a fundamental right granted by the Bill of Rights, was not considered so fundamental that it was required in Puerto Rico until Congress extended such a right. Citizenship, though coveted by many, as stated once again in Tuar, is not considered fundamental enough to warrant immediate extension to American Samoa. And though we have same-sex couples undeniably, we can't.
Counselor, if you deny people certain fundamental rights, aren't you denying them their due process as well?
Well, Your Honors, marriage is not a fundamental right. Therefore, we are not denying them a fundamental right.
Okay, so the argument you were just about to make, or your argument about denying people citizenship, the people of Virgin Islands are U.S. citizens, but they're denied certain things. Aren't they being denied their due process by being denied not being able to vote?
No, Your Honor.
Why not? Why would it be if unlike American Samoa, where I agree, they are American nationals and not U.S. citizens. The Virgin Islands, as of 1925, everyone born in the Virgin Islands is a birthright citizen of the United States. So why is it that, if your argument is marriage isn't fundamental enough to attach by itself, and we're looking at voting, what due process, why can't Virgin Islands citizens vote for president?
Virgin Islands citizens cannot vote for president because such a right has not been extended to the territories, which is equivalent to the right marriage. It is not extended, same-sex marriage is not extended to the territory. Your Honors, Tuaoa also illustrates a possible limit on congressional power and a clear limit on the power of the courts. Until a United States territory is legally and culturally ready to accept the extension of a right, one cannot be forcibly extended. I quote, "To mandate an irregular intrusion into the economy of democratic decision-making would be an exercise of paternalism, if not overt cultural imperialism," to our U.S. So sadly, Your Honors, though congressional action is the only possible way to extend this procedure to provide a right to these ladies, Congress and the courts have been once again shackled by the insular cases. To conclude, Your Honors, these ladies can take a flight to one of the 50 states, their previous residence in New York, or Ms. Buchanan's home state of Indiana, and purchase a marriage license, return to the Virgin Islands, and have a twilight wedding ceremony at Megan's Point with flowers ordered from All Occasions Flower Shop, cake from Breads and Cakes Bakery, aesthetic apparel from VI Bridal, and have a wedding of their dreams. However, what we cannot do is issue a fraudulent document that violates Virgin Islands law and current cultural norms by any means. No entitlement.
So you're saying that the Virgin Islands is more than willing to recognize a marriage license issued in one of the states?
Yes, Your Honor.
So it's your contention that the only thing that Mr. Roy and Ms. Buchanan cannot get is what? If they can get married, you're saying they still have their right to marry. The only thing they can't get, what is stopping them from just getting married? Yeah. Well, what is actually stopping them from getting married if you're saying you recognize it?
Your Honors, we're not stopping them from getting married. There is no procedure for them to be issued a marriage license, which is what they seek.
As you just pointed out, you said that they could have easily gone back to New York. They could have hopped on a Spirit flight, a Delta flight, a JetBlue American flight, gotten their license, come back. And any religious source, any judge, anyone who is able to sanitize a union would do it.
Yes, sir.
So you're just saying that they really just chose to spend money, spend time before the court for something that would have taken them 2 hours to actually decide to get?
Yes, sir. no entitlement to same-sex marriage exists, and no violation of the due process or equal protection guarantees of Ms. Arroyo and Ms. Buchanan exists. And as such, this court should affirm the lower court's decision. Thank you.
I have one final question. Is it right that you're basically saying right now that Mr. Arroyo and Ms. Buchanan just need to incur a financial cost to get their marriage license? Is that fair? Is that even right to make them do?
Your Honors, this is not a case about my morals, virtues, or personal opinion. Again, yes, Ms. Arroyo and Ms. Buchanan could have easily taken a flight to one of the 50 states and gotten their marriage license. We do not have a procedure. We do not have a procedure in the Virgin Islands for a license to be issued to them.
Counselor, if they get a license from another state, the Virgin Islands will recognize that license, correct?
Yes, Your Honor.
Okay, so then your whole argument would fail because you're just saying it's a due process issue then at that point, because you're not denying them the right to get married because you're saying that they can get married. You're just denying the process to get married, correct?
No, Your Honor.
Explain, counsel.
We're not denying them the process to get married. These young ladies, Your Honor, I see my time has elapsed. May I please answer?
You can answer the question, counsel.
Your Honors, we are not denying these young ladies the process of getting married. The Virgin Islands government does not have a procedure, and it is not culturally ready to accept same-sex marriage. And therefore, we cannot impose same-sex marriage on the territory. Thank you.
You're so good, Marius. No, you're good. You're good, Marius.
Hey, that was a really interesting argument.
Thank you.
That's probably of our four that we have, that is the most out there one, because it allows you to kind of get around the executive order, because the executive order does say you have to follow it, but they're arguing for something that you would get. You could get married, but the procedure doesn't exist, which is what you're missing, Marialis. We can't deny you something that doesn't exist.
I had no idea how bad it is to live in a territory legally. And I apologize from the United States that this is totally really bad. I mean, I can't say it with a straight face, but I mean, it's organized discrimination. And then I wish more people in the States actually knew this. Maybe we could help you guys out somehow, because this is really bad.
It actually gets a bit weirder. Our case last year was actually about voting rights, and it brought up another interesting point. Right now, two of the U.S. is actually supposed to be granted certiorari to go up to the Supreme Court. But what makes it unique is the insular cases point out that every territory should be addressed differently.
Right.
But Virgin Islands has this weird thing where no one has ever actually challenged anything specific to us. And if they did, there's this weird additional point. Every territory except the Virgin Islands was acquired by treaty of war or an acquisition at the end of a war.
Right.
Every other territory that was acquired by purchase is either a state or parts of multiple states. But no one has ever argued that in the Virgin Islands.
Yeah, that'd be very interesting, because I mean, I think you would have some more rights. I was coming back and reading the Bidwell case, and I mean, and when you take a look at the Bidwell case, Downs versus Bidwell, and then it's expressed very similar to Plessy versus Ferguson. We really are looking at like two levels of and saying that's okay, and this is like totally wrong.
And we're talking about cases that, the funny thing about the insular cases is this: the only one decided after the Virgin Islands became a territory is Balzac. Not one of them referenced the Virgin Islands directly.
Wow.
So we're really in this weird situation where the Virgin Islands may have the ability to get those cases overturned, but no one has actually challenged for it yet.
Yeah. I'm wondering why.
I'll be honest with you. My weird belief about the whole thing is it's that because of the way we're tied to the US, it hasn't gotten to the point where people really feel this need for it, especially with the fact that if this was the 1920s and it was much harder to get to the States, people would be arguing for it. But 2 hours to Florida, you can technically vote. So it gets to this point where no one is really arguing for them yet. They're starting to come up now, but the Virgin Islands might be the very chisel that the other territories need.
Wow. Now, correct me if I'm wrong, but I had this argument, especially on your voting rights case from last year. You could be from the Virgin Islands and be a U.S. citizen and run for president, but you couldn't vote for yourself.
Well, actually, you could, but I'll explain how it gets weird. Yes, you could be, once you're a born citizen of the United States Virgin Islands, you can run for president, but you would have had to have resided in a state for a year before. You can actually reside in the Virgin Islands for your entire time and meet the requirement.
Okay.
But that year before you run, you have to reside in a state.
Wow. But then we could have somebody like Ted Cruz, who was born in another country and had dual citizenship, and he could run with a straight face. That doesn't seem to make sense.
It doesn't. And the funny thing is, maybe if he was the nominee, we would have been faced with a unique situation where that would have come up. But yeah, you could very well run for president from the Virgin Islands, because if it was a case like with the Northern Mariana Islands, theirs is a bit weird.
Right.
At one point, your time in the Northern Mariana Islands wouldn't come toward your time being in the U.S. The Virgin Islands always has. And our laws specifically, including the way we were acquired, get really bizarre because the documents of transfer from Denmark pretty much say, though the official transfer was the 31st of March, anyone born after the 1st of January 1970, the moment 1925, February 25th hit, they could have been in any place in the United States, unincorporated territory or not. They were instantly U.S. citizens.
Wow.
They could have been in the Philippines, they would have been U.S. citizens.
Right.
Nobody else in the Philippines would have gotten that on that day.
In when you were part of Denmark,
Mm-hmm.
were you a territory, or what were you considered part of Denmark?
It was weird because that entire point of history is one of those unique things for any Caribbean island. We were a territory of Denmark, but we weren't. It's weird because at that point in time, up to 1917, the Virgin Islands was actually used as a free port. So we had jumping back into our history a bit, in 1898, actually, the same time Puerto Rico was acquired, there was a tidal wave in the Virgin Islands, an earthquake and a tidal wave. And one of the earliest reports about that incident was from a naval ship docked in St. Croix, a U.S. naval ship docked in St. Croix. So the U.S. has been kind of trying to have with Germany since about 1868 to buy the Virgin Islands. It's just that the final sale didn't go through until 1970. So though we were Danish at that point in time, because of the position, U.S. money was the currency.
Oh, wow.
It's a lot of little weird things specific to us that the other territories haven't really had to deal with.
Right.
So there's even one of our senators actually proposed that the U.S. should. It's a weird thing because I don't necessarily agree with his views on it, and I kind of know him personally. His comment was the U.S. should apologize for purchasing the Virgin Islands, at least to the Virgin Islands people, because the people had no say in it. And it's weird because $25 million is a chunk of change to put down for the Virgin Islands when you just got in Puerto Rico in 1898.
Yeah.
So the U.S. bought the Virgin Islands for strategic reasons, but in a way provided for more rights than any other territory at that time. And the Organic Act, I'm glad that your students looked at the 36 and the 54 versions of it. 36 makes no mention of us being an unincorporated territory.
Right. And
only until 54.
Right. And I think they did that to gain more power over the situation. I mean, it's a deliberate point of change that they realized that they were trying to slip one over, I guess, is what you try to say. That's really that unfair. And you don't really see that, but we're having a little bit of the stuff coming from Puerto Rico with the recent bankruptcy and different things. Now, I had no idea. We've been working with the JAG Corps doing some law day stuff for them. And one of our partner lawyers from the JAG Corps was from Puerto Rico, Miss Maldonado, and Captain Maldonado. And she was telling us that she is, I said Puerto Rico, and her parents were up here and they came by and visited us. And they were saying about the laws that you can't have to use American ships to go to from place to place. And you can't make treaties. You can't do this. You can't do that. So basically, you're kind of tied on your commerce and your trade on what you can do. So it's very difficult to have free reign to gain any taxes or whatever you want to do.
And I actually think Puerto Rico is in a weirder situation than us, simply because the word Commonwealth, people tend to believe that it actually means that their status is different compared to theirs than ours. Commonwealth is just a phrase. The Northern Mariana Islands are a Commonwealth of the United States also. They're still unincorporated territories.
Yeah, and even though it's supposed to be just underneath a state, doesn't mean they're going to get statehood any quicker nor any more rights. It's it's just like a supersized hamburger. It's not any bigger. It just costs more money or whatever.
And I am actually one of those people who in regards to the Virgin Islands, Puerto Rico is a little different. I do believe they could make a better argument for statehood because of their size. I actually think that there's an additional option because the whole UN Charter in regards to the removing of the colonial status in regards to overseas governmental territories says that sovereign nations must give territories the ability to self-determine. I don't think that the only choices we have are free association, status quo, or statehood. I'm actually not of the belief that Congress would go out of its way to allow us to say we're incorporated and they'll think about that. But I think there's a fourth option nobody's addressed. The District of the Virgin Islands.
Yeah.
There's an entire amendment provided for that. Why not just provide an amendment that creates a special district because we won't have the population size to become a state. But if you go to a special district, you inherit those, you can still inherit the same form of federal taxation if it comes down to it, without having to worry about population size, districting, appointed senators. You can very well just say, okay, the Virgin Islands gets one senator due to its size. And it adds an additional congressperson, just the way DC says that they get an apportionment of an electoral college voters equal to the least popular state in the union. We could very well get the same apportionment -1. That would give us 2.
Yeah. Well, this has been fascinating to me because I had no earthly idea, and actually, Northern Mariana Islands have a moot court too, and it would be kind of neat to get both you guys together and do stuff like this to have territory. And their cases hadn't been so territorial; they've been mostly like regular state cases. So I guess we didn't know the plight of the territories until we actually picked this up, and it's really been an eye-opener for the girls because they've been working really hard trying to prepare to at least give you some arguments about that. So we wish you the best of luck. When is your competition?
They pushed it back a week, so our first day is the 31st of May.
Okay.
And finals will be on the 2nd of June.
Wow. And you guys win quite a bit of times, don't you?
We actually have won the last 3, and we have about half of the wins for the competition. But This year, I'm honestly not sure how that's going to play out because we're not sure who the other schools locally are. So we have taken the last three. We're kind of attempting for a four-peat this year. We were the first school to ever win 3 back-to-back. We're trying to be the first school to win 4 back-to-back also.
Oh, that's good. Congratulations. You do a really good job. Your kids are very good.
And we're actually missing one of our arguers. She's actually away on a close-up trip to DC.
Oh, wow.
So she is actually off island. And it's just a matter of figuring out who our 6 are, because we're pretty much down to 7, and we're hunting just to make sure that 6 we put forward are the strongest 6 we can find.
Good. I wish you guys the best of luck, and I'll be emailing you because I'd like to try to do some other stuff. When does your school year end and begin?
Our school year ends, the exact day this year is actually the 22nd of June. Okay. I still have access to my school email all across summer though, so I consistently use my school email. We start back this year, the first week in September, I believe. I think we start back that first week in September. I can actually give you the exact date. Give me a sec. Mm-hmm. We return, actually, yeah, our first day of school is the 6th of September.
Okay.
Well,
I'd like to try to see if we could we could get you involved. We could get you involved in doing some stuff in Australia where you could actually be in a courtroom in Australia and you can present a court case. We do the same with Ontario in Canada. You could be in a Canadian law case. And then we do, we'd like to do one like with you guys in your territory, and then we invite you to do one for, we have our Army, J-Corps will work with you, and they can actually work with you through the computers too. And they would help you out, which they would think would be kind of neat because we have quite a few there from the territories. So they would maybe even get a territory case, and they would really like it. I mean, I know Captain Maldonado was, she was wanting to come today to actually talk with you because she's, like I said, from Puerto Rico, but she's very interested in territorial law.
All right, well, if I've never even used Zoom until today. I kind of like how it's set up. If you can get her for a day, anytime next week, I could even see if I could get the team. I tend to meet with them daily. It's just that we don't always get everybody. Mm-hmm. If it comes down to it and she starts the time to meet us and you could give me a date, I'd have no problem scheduling another go around. By then, we should have the arguments a bit more polished, have those intros and outros hammered, and we'll be good.
Yeah, I'll try to get a hold of her this weekend, and I'll try to shoot you an email, and I'll shoot you an email and telling you when the links are, what the links are to this, so you can watch your kids. Okay?
That'll be excellent. I'll touch base with our administrator so they can know how this went, and let's see if we can officially get it started. So next year I can just build my team from the start of the school year and we work our way across the whole thing.
Well, what we would do is you really would get a international feel, and we would get a good territorial feel too. But you could actually, kids could experience, and they would be cross-examined by judges in Ontario and in South Australia. And if we get really lucky, we're trying to get South Africa too. So that would be really kind of nice all the way around.
That would be excellent. It helps us. It helps us to broaden their horizons and their view of the world, because it always helps to learn about how places operate, especially legally. Period. Especially from us, who people tend to believe we're on this nice little small island and we don't know more.
Yeah, I don't think there's any place anymore you can really hide and it's perfect. So, I think they could actually see that kids will be kids and adults will be adults and crooks will be crooks.
Pretty much.
And lawyers will be lawyers, and we'll see what happens. But I'll say goodbye today, and thank you so much, okay?
Thank you. You have a question?
Bye.